Here at Scott Legal, we have processed hundreds of E2 visa applications. While past results do not predict or guarantee future outcomes, we have a 98% E2 visa approval rate. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. One of the most common questions we receive is, should I apply for an E2 visa at USCIS, or at a consulate? In this video, we will discuss the pros and cons of each. Those who are in the US, and who did not enter under the Visa Waiver Program, or ESTA, have the option of applying for an E2 visa either at a consulate, or at USCIS, through a process called Change of Status. Keep in mind, E2 visa applicants who are outside the United States, must apply at a consulate. So is applying through a consulate, or USCIS the better option? There are a number of pros and cons to each, that should be considered. Most E2 applications are filed at consulates, and there are a number of good reasons for this. First, consular processing is cheaper. For example, premium processing fees are currently $2,500 and can go up depending on USCIS changes. However, the filing fee for consular processing is $205. Also, in normal circumstances, consular processing takes about the same time as premium processing at USCIS. For example, prior to the pandemic, normal processing times in Toronto were around 3 weeks. In comparison, premium processing normally requires 15 days, but could be longer if USCIS issued a request for additional evidence, or RFE. Note that the COVID pandemic has caused severe backlogs at some consulates, making normal processing times much longer. Another reason why applicants tend to prefer consular processing is that USCIS puts an extreme focus on the source of funds used to invest in the business. A USCIS petition must usually include extensive documentation showing how the applicant acquired the funds invested in the business. This makes the USCIS file longer and more time-consuming to prepare. USCIS is also extremely particular with respect to the source of funds. It is common for USCIS to issue a request for evidence, or RFE, asking for additional evidence. This can result in further delays and additional work on the application. In contrast, consular filings normally have very limited information on source of funds, and consulates rarely focus on this aspect of the application. Also, consulates issue an E2 visa, while USCIS does not. Instead, USCIS provides 2 years of E2 status, which allows the applicant to stay in the United States. However, the moment the applicant leaves the US, they will need to apply for an E2 visa at a consulate. This requires an entirely new E2 application, since the consulate typically will not defer to an approval from USCIS. Therefore, unless the applicant plans on staying in the US without leaving, processing the visa at a consulate will be inevitable. Finally, USCIS requires that applicants demonstrate maintenance of status, while consulates do not. This may require, for example, showing USCIS that the applicant did not perform unauthorized work when setting up the company on a visitor visa. It can be a burdensome requirement that is avoided by applying through a consulate. So who should apply through USCIS? Those whose local US consulate is experiencing significant delays should consider USCIS. The pandemic has delayed processing times at some consulates substantially. As a result, a USCIS filing may be the last resort for some who are in the US and want to start their business. Applicants who have invested a relatively small amount in the business should consider USCIS. Our experience has been that USCIS does not deny applications just because an investment amount is low. On the other hand, some consulates systematically deny applications where the investment is under a certain amount. It is worth noting, our firm regularly processes E2 visas with low investment amounts at consulates, and many consulates adjudicate petitions in a manner similar to USCIS. A qualified immigration attorney can help you assess the available venues so that you can make the best decision. Those who are nationals of countries that provide a short visa reciprocity period should consider USCIS. Certain countries will only grant investor visas to US citizens for a short period of time. In these cases, the US reciprocates by limiting the length of time nationals of these countries can receive an investor visa. For example, nationals of Bangladesh can only receive an E2 visa valid for 3 months, which means they would need to enter the US within 3 months of receiving the visa. It is important to note that visa validity is not the same as E2 status. Once an applicant enters the country, they are given 2 years in E2 visa status, even if they enter on the last day of their E2 visa. However, when an individual with a short reciprocity period leaves, they must apply again at the consulate in their home country to renew the E2 visa, and some countries limit the number of possible renewals. Therefore, in a situation where the reciprocity period is very short, a change of status may make more sense. Finally, those who have a pending green card petition should consider USCIS. An applicant who has a pending green card petition may have an easier time getting an E2 visa through USCIS than at a consulate. We recommend that those in this situation speak with a qualified immigration lawyer in order to carefully navigate through this process. It is important to work with an attorney who understands the differences between applying at a consulate and USCIS, as well as how those differences relate to the specific circumstances of your case. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.